Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Liles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Risks Facing Your Home Health and Hospice Agencies If You Hire Someone from the OIG Exclusion List or the CMS Preclusion List. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we'll address as many as possible at the end of the presentation. So without further ado, I present your speakers, Robert Liles and Ashley Moore.
Thank you very much, Giovanni. I appreciate it. As you can see on the screen, I was originally going to do this presentation with my colleague, Paul Weidenfeld. Paul and I have known each other for many, many years. We were both federal prosecutors at the same time. He was a federal prosecutor in New Orleans, while I was a federal prosecutor in Houston, and then I came to D.C. I'm sitting here today, though. Paul could not make it. He had a case conflict, so he's not here today, but I've got someone even better. I've got my partner, Ashley Morgan.
Hi, Robert. Good afternoon. How you doing?
Doing fine, Ashley. Doing fine. I know this is a topic that's right up your alley because you're currently defending a number of these preclusion matters, and you've done a number of these in recent years. Is that correct?
That's absolutely right.
Okay. So we're going to go on and begin because these are some issues that I think that everyone that's on this call, home health and hospice, these are probably two of the biggest risk issues that you didn't even know you had.
That's right.
Now, I'd like to start out by pointing out that the landscape when it comes to payers is going to be changing in the near future.
That's right. So CMS is really actively working to move all Medicare beneficiaries onto an accountable care plan, and they're not hiding that fact. They've announced it. They've said that CMS has an initiative to move all of its patients off of traditional Medicare, and they're trying to move everybody over to Advantage plans.
Now, this is I think it can be a problem. Nationally, it's already more than 50% of the folks on Medicare are on an Advantage plan. Okay, in Texas, the Medicaid managed care plans, that's almost complete. It's more than last I saw it was like 90%. Mm-hmm. The reason why this matters, though, my friends, is that every one of these Advantage plans, and this is something I want you all to kind of keep in mind, they are not all created equal, are they?
No, they are not. They all have their own different quirks about them. They all have their own different specific rules, and they all have their own different appeals processes. That's
right. So to the extent that you find yourself in a bad spot because you've been, accidentally brought somebody on who is been excluded, or you find out from these guys, from the Advantage plans, that someone's on the preclusion list, because that's something they don't even have providers don't have access to that, do they?
No, they do not.
So it's really, by the time they learn about it, it's too late.
That's right. That's right. You're getting notified by a payer.
Then it's just damage control.
Mm-hmm.
Okay. But that is something to kind of keep in mind because this really impacts you across the board in terms of administrative appeals, what kind of issues they're looking at, how aggressive they are when it comes to audits, and these preclusion issues that we're going to be discussing. All right, so what is the preclusion list, and when in the world did this come around?
So it really is, relatively a new thing. It has not been around for that long.
It really hasn't.
Mm-hmm.
It really hasn't.
It's in 2018, the CMS issued a final rule that really essentially announced that they were going to be starting this preclusion list program, which specifically applies to Medicare Advantage plans and the prescription drug benefit program. They kind of realized there was a hole there for people who were either revoked or excluded. They wanted to make sure there was a separate list that applied specifically to those lists. So effective June 15, 2018, CMS was finally required to actually establish this preclusion list. And there is only one preclusion list. And I know it's kind of alphabet soup here. We've got revocations, we've got preclusion lists, we've got exclusion lists, but this is its own individual preclusion list.
And part of the reason for this, of course, is, around the same time is when CMS kind of withdrew from the credentialing process for Part C and for Part D.
Mm-hmm.
And in conjunction with that, they said, well, if we're not involved in the credentialing and determining who's going to be a participating provider for the Part C and Part D plans, they're handling that on their own. They need to have their own list of bad actors.
That's right. They need to have a list that they need to check to make sure that these people are not allowed into the program.
That's right. That's right. Next slide. So the preclusion list then is something that is the only people that really have access to it are the government, you know, CMS, OIG, and then the plans themselves, Part C and Part D. So it's not like you can pay an organization like Exclusion unless you work for a payer. If, you know, any payer can access it, but Advantage Plan. But it's not like you could pay somebody like exclusionscreening.com to tell you, is Dr. Jones on the preclusion list, because providers do not have access to it.
That's right. That's right.
Okay. All right. So what is the purpose of the preclusion list then?
The purpose of the preclusion list is essentially just a register of healthcare providers, suppliers, and prescribers who are not permitted to receive reimbursement for Part C Medicare Advantage items or services, or Part D drugs that are provided or prescribed to Medicare beneficiaries. So it's essentially its own list of providers who cannot provide services to Medicare Advantage patients or prescribe for Part D drugs.
Okay. All right. So while Part C and Part D have their own SIUs, they have their own groups they handle credentialing. The fact is CMS is still kind of pulling the strings, because they say, you're contracting for us to administer these programs. We don't want our beneficiaries to be treated or handled in any way, you know, by bad actors. And it's interesting because this term bad actors is actually language that they use in the Federal Register.
That's right.
And the reason for that is, once we compare preclusion to exclusion, you know, exclusion, if you're excluded from participation, there are very specific rules, very hard and fast kind of rules that are followed, at least on the mandatory side. On the permissive side, they're a little looser, but the fact is, unless there's a reason for OIG not to exclude somebody, they almost always do. It's a lot squishier, if you will, when it comes to preclusion. So they just kind of characterize them as bad actors.
That's right.
All right, so what are the different, you know, what are the ways that a doc, let's just use a doc for our example, okay, or a nurse. What are the ways that they can find themselves on this bad actor list, this preclusion list?
There are a couple different ways. One of the most common ones I will say that we see is related to a revocation. So if you are, for example, a physician, and you receive a letter from your MAC or from the Provider Enrollment Oversight Group at CMS that says you are revoked, in almost every single one of those letters, we also see that in addition to the revocation, you are being added to the CMS Preclusion List. And that is because the first category that we really have for a provider that's being added to the preclusion list is based on a revocation. And we have the specific rule up for you on the screen, the regulation, that essentially says they can add you to the preclusion list if your Medicare billing privileges have been revoked, and if you have an active re-enrollment bar. And my favorite category that CMS typically always includes in revocation or preclusion type of regulations is if they determine that the underlying conduct that led to the revocation is detrimental to the best interest of the Medicare program. And they have a couple of different items that they consider there, but they have a catch-all at the bottom that says any other evidence that CMS deems relevant to its determination.
And that's why I think it's so squishy.
That's right.
Because basically, if CMS doesn't like you,
they can keep you out.
They can keep you out.
That's right.
Mm-hmm. So this first category is revocation-based. So let's talk a little bit about, and that's really primarily how this comes up.
That's right.
But let's talk about what can trigger a revocation.
Okay. So there are a number of reasons that you can be revoked for Medicare. Those include failure to report a change in location, failure to keep proper signage or regular business hours, failure to report a final adverse legal action. So for example, if you have a prior felony conviction within the past 10 years and you never told Medicare about it, you can be revoked for that.
And you've handled a number of those cases, haven't you?
Yes.
In fact, we have seen CMS revoke docs who actually disclosed a prior conviction and they described what happened, but they accidentally, in a different part of the application, when asked, have you been convicted, they said no.
That's right.
So even though they disclosed it,
Mm-hmm.
they, you know, they accidentally, or their assistant put no, and they were revoked.
That's right. That's right. I mean, they take a very hard line on your failure to report information to them. And if you have one issue on that application, you can be revoked. Or even if you report, for example, if you have a felony conviction and you're excluded, if you report the exclusion but not the felony conviction, that's still a problem, even though they're related. So you have to be very careful about how you report this information, because if you fail to do so, you're revoked and you're out and precluded, and you're out of the system while you're fighting those appeals. Billing for deceased beneficiaries, one of my favorites.
Yeah. And one of the ones that comes up a lot with home health is failure to report a change of location.
That's right.
Or failure to keep regular business hours. Can you kind of talk about some of the examples of those cases? Because we've handled a number of those.
That's right. And so that comes up a lot specifically with home health and hospice, because you do need to have a physical location for your office staff. You need to have a physical location that needs to be reported to CMS and needs to be accurate, because CMS will do essentially a drive-by site visit. And they'll see if you are actually at the location and if you're open during the hours that you say that you're open. And if you have somebody there that's answering the phone and say they had to step away for a phone call or lunch, something like that, and they're not there when the drive-by occurs and you don't get advance notice of these site visits, then you'll just get a letter in the mail that says you're being revoked, and they'll retro it back to the date that the actual site visit happened.
Now, when you say CMS, in most cases, it's their contractor.
That's right.
You pick.
That's right. So
that will go out and check you out.
Yes, typically the MAC. So Palmetto, for example.
Or the MAC.
Yeah, we'll do a drive-by and see if you're there, and if you're not, then you'll get a letter based on that. And sometimes we also see these cases in connection with a home health or hospice who has used somebody else to do their credentialing, and they'll put in the wrong address for their physical location. They'll put in either their mailing address, which might be a P.O. box address, or they'll put in the address of their, if it's the biller, for example, who's completing their application, they'll put in their address.
We've had a couple of those cases.
We have,
and we've had it to where they show up and say, where's the home health agency?
That's right, and they're not there, and you don't typically get a second bite of the apple on that. They'll just send you a letter and say you failed the site visit, you're revoked, and you're being added to the preclusion list. So very important that that information gets reported accurately, and that you're operating your business like a business, that you keep regular hours of operation.
So these are just summary kind of reasons for revocation. Let's go to the next slide, and we can actually look at the actual regulations themselves. And you can see that the ones in black, those are the original bases for revocation prior to the changes in 2019. Okay, and then the ones in the red there, they updated those, and then they added 13 through 21.
That's right. That's right. And some of the ones that have been added are pretty pertinent. For example, the debt referred to the United States Treasury. If you have,
well, that's the next slide. Because this is the original group of additional provisions. And then go to the next slide, Gio. And then this last summer, it became effective in January, but I don't think they issued the final rule until the summer for some reason. I'd have to double check that. But they went in and they added some additional bases for revocation, and then they tweaked some of the others.
That's right. And the ones that we have here, so we have misdemeanor convictions. Those were added. So, felonies have always been an issue. But if you have misdemeanor convictions, you can be revoked. If an owner or managing employee has a misdemeanor within the previous 10 years, that CMS, again, deems detrimental to the best interest of the Medicare program. And False Claims Act civil judgments, which I think is really interesting, because this has been modified so that CMS can revoke a provider if the provider or supplier has had a civil judgment under the False Claims Act imposed within the past 10 years. However, they carved out the definition of civil judgment to not include settlement.
And that's because most settlement agreements would say something like, this is a case that was brought under the False Claims Act, but everybody, the defendants contest, any liability, and there isn't any kind of judgment. It's just a settlement.
That's right.
So there's no finding of liability under the False Claims Act.
That's right. That's right.
Next slide. Okay.
And so here is the discussion of the debt that's being referred to the United States Department of Treasury. So here, if you have previously worked for a company or owned a company or been a managing employee, not worked for a company, actually a managing employee or an owner of a company that had a debt that was assessed essentially by Medicare. And if you sold that company, or if you just, previously worked there and you left and you were a managing employee there, you're a managing employee at this new company, or you're an owner at this new company, and that debt, it goes through the administrative appeals process, and, the administrative appeals process is exhausted, and you do not repay that debt, or if you just don't appeal it and it gets referred to the Department of Treasury and it's unpaid, then you can be revoked. If you are an owner of a new company, that new company can be revoked based on your prior affiliation with a company that owed a debt to the Medicare program. So it's really important that if you own a home health or hospice agency and an overpayment is assessed against you, that you are fighting those cases through the administrative appeals process and to try to make it so that you have a debt that's manageable, and that debt does not get referred to Treasury, because it can impact any other businesses that you own or are affiliated with as a managing employee.
Okay, next one. So what about, we've talked about the revocation basis, okay? Now we're going to kind of switch gears. There's a second category of reasons why you can be put on the preclusion list.
That's right, and this is just about behavior-based. So this looks specifically at if an individual or entity has engaged in behavior that CMS could have revoked the individual or entity if they had been enrolled in Medicare. So this gives them an additional option that if you maybe weren't a Medicare provider, or if for some reason you are a Medicare provider and you weren't revoked, you can still be precluded. Even if you didn't get revoked, or even if you weren't enrolled in traditional Medicare, you can still be added to the preclusion list for those same reasons that we just discussed. And in addition to that, if, again, the underlying conduct is detrimental to the best interest of the Medicare program. So this is just another option for them, that if you weren't actually a Medicare provider that was revoked, they can still add you to the preclusion list to keep you from participating in Medicare Advantage and prescribing for Part D.
Exactly. Next one. All right. So we've got all these different things. We've got revocation-based actions. We've got behavioral-based actions that can result in an individual or an entity being placed on this preclusion list. How, if home health and hospice agencies and individuals don't have access to this list, how are people supposed to know that they're on the list?
Well, you are supposed to receive written notice. You are supposed to receive a letter that says you are being added to the preclusion list, and you have an opportunity to file a request for reconsideration of that decision. If you do not receive that letter, then a lot of times the way people unfortunately find out that they've been added to the preclusion list is because their claims start getting denied. Then they've been added to the preclusion list, but they don't know, and their claims won't get paid because they've been told that they've been terminated, but they never found out. So you should get a letter. If you do not get a letter and you just start having claims denied, if you reach out to the Advantage plan, for example, and they say, well, you're on the preclusion list, that should start sending red flags up. We need to reach out. We need to get a copy of that letter that was sent out, which you should be able to get. It may have unfortunately went to the wrong address if, for example, you had the wrong address on file, but we should be able to get a copy of that and then file an appeal. And if the appeal rights have lapsed, but you never actually received a copy of the letter, then typically we can resolve that through the appeals process. But there is an appeal. I will say with preclusions, unlike revocations, if you appeal the preclusion when you get the letter, the effective date of the preclusion is typically when that reconsideration decision is issued. It does not take effect necessarily the same day as a revocation.
So it's typically stayed.
That's right. That's right. So it's very interesting when you have a dual case that's a revocation and a preclusion, because the revocation will typically take effect while the appeal is pending. But the preclusion you can offset until you get that reconsideration decision, which typically takes, you have typically 60 days to file a request for reconsideration, and then it takes anywhere from 60 to 90 days for the preclusion appeals can sometimes go to the MAC directly, or sometimes they go to the Provider Enrollment Oversight Group in Baltimore that's typically specified on the letter, but it typically takes them about 90 days to issue a decision.
Gotcha. All right, so how long can an individual be on this preclusion list?
So that depends, and it depends on what the preclusion is specifically based on. So if it's based on an exclusion, then you will be on the preclusion list for the length of the exclusion. Once you are removed from the exclusion list, you'll also be removed from the preclusion list. Same thing with revocation.
Well, let's talk about that, the revocation, for just a second.
Mm-hmm.
Prior to September or whatever the effective date was, when they made the changes to the revocation rules, how long was a revocation action?
Revocation action was 3 years. That was the max.
But now, with the changes, not only did they expand the reasons that you could be revoked,
Mm-hmm.
but they also greatly expanded the period of a
That's
revocation action, didn't they?
That's right, Robert. Now the maximum amount of time is 10 years, and we see them use that 10 years all the time, unfortunately.
But you know, not always, but you've got a pretty good track record of trying to either get it to go away or negotiate something far less egregious.
That's right, because if you are revoked, for example, if you cannot get CMS to overturn the underlying revocation, the minimum period of time that you can be revoked is 1 year. So we do have a lot of success in arguing that it's essentially called the re-enrollment bar period. That's the period of time when you're not permitted to try to re-enroll
Mm-hmm.
in the program.
Yep.
So we have a lot of success in fighting that time period and getting it reduced down. But it's shocking when we get these letters, because a lot of times, you know, there's a lot of leeway in there for the period of time that they determine that enrollment bar to be, and we see that 10-year all of the time. So it's very important to get those letters and fight those decisions, because like what Robert was saying, if you've got that re-enrollment bar for the revocation, you're not going to be in traditional Medicare, and you're going to be on the preclusion list as well, so you cannot do Medicare Advantage as well. And similar to the revocation, for if you're added to the preclusion list based on a felony, that's going to be a 10-year period. The CMS actually will not actually approve a enrollment application if you have a felony conviction within the past 10 years. So if you are added to the preclusion list based on a felony, similar to the enrollment rules, for preclusion, you'll also be on the preclusion list.
Now that's just almost crazy, because let's just say that an individual doc is convicted of a healthcare fraud felony. Theoretically, they could get as little as 5 years on the exclusion list.
That's right.
Which up to now has been the 800-pound gorilla.
That's right.
Right?
Mm-hmm.
What you're telling me now, though, is this administrative action for being a bad actor and being revoked, even even based on the felony itself, even though you may be off the exclusion list after 5 years, this preclusion action can still continue.
That's right. And that is a big problem for providers, because you can get off the exclusion list, you can get a license to practice, but you cannot participate in traditional Medicare, you cannot participate in the Advantage plans, you cannot prescribe.
Wow.
Mm-hmm.
Next slide. All right. So, how in the world can a home health or hospice screen for preclusion? We're talking about exclusion just a minute.
Yeah.
For preclusion, how can they screen?
It's really difficult, because only, as Robert has said previously, only CMS approved Medicare Advantage plans and Part D payer plans have access to the preclusion database. I will say that we have contacts at CMS where we are able to reach out and ask them if a provider is on the preclusion list, and we can ask them. But you, as a home health or hospice agency, you don't have access to check that list. So it's important that when you are bringing in new hires, that's a question that you ask.
Yeah. Now, just to be clear, though, that's not something that we can really pick up the phone and call as a screening process.
No.
Really, that's when that pops up, it's, hey, Ashley, we're not getting paid.
That's right.
What's going on?
That's right.
And then we get on the phone and we talk to them and we ask them the 10 questions of why aren't they getting paid, and that's one of them.
That's right.
Right?
And I will say, recently, this has been something that I've seen recent, is that preclusions should be getting reported to the National Practitioner Data Bank.
Mm-hmm.
That's not always true, but they should be getting reported to the NPDB. So if providers are doing self-queries, they should get notice of it there.
Of course, they're also supposed to get the letter.
That's right.
To begin with,
That's right.
But they may not.
That's right.
Okay, next slide. All right. So what does credentialing have to do with anything?
So credentialing is essentially filing an application with an Advantage plan saying that we wish to enroll in your program. We want to be a provider.
Yep.
And there are specific pieces of information that have to be disclosed on the credentialing application. Then once you submit that application, the payer will screen you. And that it's at that point that they'll look at that preclusion list to see if you are listed there and whether or not you're going to be able to participate in the program.
Okay. All right, next one. All right. And we kind of talked about
we
that.
talked about this, that,
Next
you know,
slide.
it's
Yep.
difficult to know.
Okay, so how do you appeal?
So if you find out that you have been added to the preclusion list, if you get this letter, we always recommend that you reach out to healthcare counsel to handle these types of appeals, because the initial appeal, the request for reconsideration for a preclusion action, that's your evidentiary deadline.
Mm-hmm.
So any evidence you want to be considered by the provider enrollment oversight group, for example, in that appeal needs to be submitted with that initial appeal, which has to be submitted within 60 days of the date of the letter that you receive. Like I said previously, if you don't receive the letter and you just find out you're not getting paid, we have been able to appeal those and deal with the timely filing issues. But you need to get, as soon as you find out there's a problem, you need to get counsel involved to help you develop that case and make sure you get all of that information into the record for consideration. That initial decision will come back within 60 to 90 days. You may get a favorable decision there. If you do, for preclusion, you will never have been added to the preclusion list because, like I said previously, the preclusion is stayed while that request for reconsideration is pending. If it is unfavorable, that's when you're going to be added to the preclusion list. Mm-hmm. And then you're going to need to file a request for ALJ hearing, which is a 60-day deadline to file that. And in the meantime, you're likely also going to start getting termination letters from your payers,
right,
from all the Advantage plans.
And that's the problem with all of these types of administrative actions, is it's like a snowball slowly going down the mountain.
That's right.
You know, it starts out kind of small, but as more payers hear about it, then they terminate you, and it's just one thing after another, and it's very hard to stop.
It's very hard to stop, and one thing I will also say is that if your home health or hospice does any commercial with these plans that are also Medicare Advantage plans, they will terminate all your lines of business. They will not just terminate the Advantage plan. And you can appeal that decision, but it's very hard to fight because they'll typically say, well, if you're not permitted to participate with the Advantage plan, then we don't want you to participate with our commercial.
Yeah, we don't want bad actors dealing with our patients just because they're not government patients.
That's right. That's right.
Next slide. Okay, so let's shift gears now. So that's the preclusion list. And I will tell you just one last comment about preclusion. If you're ever facing a preclusion problem, I do recommend that you call an attorney that has experience handling these types of issues. This is a very specialized area. There aren't that many cases out there, and you need to find someone who has essentially gotten knocked around a little bit, because the rules are still kind of being set to some degree. Right. Mm-hmm. You know, I mean, they're kind of out there, but you know, then the whole question it comes up, well, if they've been on the preclusion list and we build and we have all these denials, you know, what do we have to pay back? Mm-hmm. What, you know, how much is there an overpayment? Are we responsible for that? You know,
right. That's right. That can be a real issue, especially that comes up a lot in site visit cases and felony cases where the action goes back retroactively, and you can have a real issue there with having to repay and having overpayments potentially for services that were provided sometimes years in the past.
And to even further complicate things, to the extent that you know you have an overpayment and you don't report it and return it, what happens to that?
That can be considered a reverse false claim under the False Claims Act, because you have knowledge about that overpayment, you never repaid it. So then instead of just being liable for the actual overpayment amount, you can be liable under the False Claims Act for False Claims Act penalties for each individual claim and for treble damages.
Exactly. All right, so we're going to shift gears now. We talked about preclusion. If you guys have any questions, or I'm sure y'all don't have any, but you may have friends who do, give us a call. We're happy to address them. Exclusions. Now, the exclusion list is something that has been around for a long time. And Congress originally, as part of the Medicare, Medicaid, Anti-Fraud and Abuse Amendments, way back in 1977, you know, they passed legislation that mandates that certain individuals convicted of program crimes must be excluded from participation. And when, you know, what does that mean exactly, be excluded? It means not only can they not treat and bill for Medicare patients, and other government patients, but they can't have anything to do at all with any part of the basket of services.
That's right.
Okay, so a lot has happened over the years. They first passed the statute, then they started, they passed additional laws later on that added on to the civil monetary penalties that could be assessed. Then they, in 87, they kind of differentiated between, well, these things will always result in exclusion, but there's a whole category of violations like licensure terminations and other certain misdemeanors and the rest of it, that it's going to be the discretion of the OIG whether or not they want to exclude the individual or entity. And those are referred to as permissive exclusions, right? A number of additional laws have been passed over the years. OIG has issued various edicts regarding how you're supposed to deal with these things. Because here's the really crazy part: if you hire someone who has been excluded from participation, okay, you're subject to significant overpayments and civil monetary penalties. Okay, but there is no law that says that you must screen. It really is kind of the carrot and the stick. So you're not forced to screen, but if you don't screen and you hire someone on the list, you're in a lot of trouble.
That's right. You got a lot of money to repay.
That's right. Next slide. All right, so there are two types, as we talked about. There's two flavors, if you will, of exclusions. There are mandatory exclusions. Typically, what are those involved?
Healthcare fraud, convictions, drug offenses, sometimes patient abuse cases there, but they're really specific in what CMS and OIG would consider egregious.
Yes, yes. And then the other flavor, of course, is permissive exclusions, and those are the ones I mentioned that is under the law. The government doesn't have to exclude you, but the discretion for deciding whether or not to do so lies with the Office of Inspector General.
That's right. That's right. And a large number, I would say, of permissive exclusions are based on licensure actions, but there are a lot of other reasons. I mean, for example, there's ones for defaulting on your student loans. If you're a physician, for example, yes, you can be added to the.
But the reason why this is so important for home health and hospice, in my opinion, one of the reasons why, is because by and far and away, the greatest proportion of individuals who are excluded from participation in federal health benefit programs is nurses of some flavor.
That's right.
Whether it's nurse practitioners, registered nurses, nursing assistants, whatever it is. And Lord knows, home health agencies employ a lot of nurses.
They do. They do. That's why it's so important to protect yourself, essentially, as insurance and screen these people.
You must. And we'll get into what that means exactly, but the point is that the home health agencies, nursing homes, hospices, any one of these disciplinary or industry areas where they employ a lot of nurses, you have a significant risk of bringing somebody on who is excluded. And it's not enough to put in your employment application, are you or have you ever been excluded? Because these individuals are smart and they know if they say yes, you cannot hire them.
That's right. I mean, and for you as the home health or hospice, it's essentially strict liability. If you have hired one of these people and you didn't know about it, you're still responsible to repay that amount.
Yeah, and that's even, as we're going to talk about in a few minutes, let's say it was for 5 years and it was 10 years ago. This happens all the time. They would tell you, well, I didn't think I was excluded. I was only excluded for 5 years. That was 10 years ago. Surely I'm no longer excluded. Unfortunately, you have to, the individual or the entity that's excluded has to affirmatively go in and apply to be taken off the list.
That's right. That's an excellent point, Robert. And also, sometimes you can be removed from, for example, the federal list, but you may still be on a state list, or vice versa.
That's right. And they cannot hire you if you're on either. Next slide. Okay. Now, we routinely get folks that say, I'm already doing this. We do background checks. Are background checks sufficient?
They are not. They are not the same thing, and I would say that's probably one of the most common confusions about exclusions is that providers believe that because we're doing a background check, that is all encompassing. And background checks are very important, very important to do.
And required by law in Texas.
That's right, and absolutely something that you need to be doing before you bring somebody on. But a exclusion is a completely separate action that is taken after there is a final decision, for example, in a case. So if there's a final licensure decision, the exclusion takes place after that. So it's a completely separate issue that needs to be screened separately. There is a separate, more than one, database that needs to be reviewed for exclusions. And the background check is not going to necessarily flag everything that would come up in an exclusion. And the background check is not going to tell you about an exclusion at all, typically.
That I agree completely. Plus the fact that background checks are typically conducted at the point of hire, whereas exclusion checks need to be done prior to hire and then every 30 days after that.
That's right.
And we'll explain why every 30 days after that in just a few minutes. But it's actually required in Texas. You know, if you take Medicaid, you know, part of the Medicaid participation agreement says you're supposed to be doing this routinely.
That's right.
Okay, so next slide. All right, so, you know, what does this mean, you know, the reach of the payment prohibition? We've talked about how if you're an excluded party, okay, I understand a doctor with an NPI, for instance. You're excluded, you cannot bill, your NPI cannot be used to bill a federal health care program, right? But it's beyond that, isn't it?
That's right.
It's the nurses that don't have their own number that come in and take care of you. It's the assistants that clean the place up. Volunteers who are getting nothing.
That's right. We're just providing their time and trying to help out. Candy stripers that can't come into the hospital, for example.
And we've had docs who have called us up who are excluded who say, you know, while I'm working this out and I'm putting my time in, I want to volunteer my time. No.
That's right.
You cannot allow them in there. And the reason is because the position, it makes sense when you actually think about it. There are two primary reasons that CMS and OIG, the government, doesn't want an excluded party to have anything to do at all with the services being provided, whether it's custodial or food service or hands-on care. And that's because individuals who have been excluded, unlike our bad actor friends on the preclusion side, individuals who have been excluded, the government has determined that they represent a significant risk, number one, to the patients, and number two, to the federal fisc.
That's right. That's right. These are people who have had some sort of, typically some sort of final judgment that's been issued against them that the government has determined poses a risk to the program.
And maybe it's a drug crime, it could be patient abuse, could be healthcare fraud, or it could be they lost their license. You know, so these are things you kind of have to think about. Vendors and contractors. The payment prohibition extension it's not just limited to your W-2s.
That's right.
Okay, the government does not want anyone to get federal funds if they have been excluded from participation. Therefore, they want you to also screen your vendors and contractors. Now that, you know, do they expect you to do FedEx? No. Okay. They're not going to expect you to do FedEx. They're not going to expect you to do, you know, the utility companies. But if you have folks that are coming in and they're doing, you know, work inside, maybe, hazardous waste pickup, that kind of thing, you're going to at least need to be screening the company.
That's right.
Technically, the company is supposed to be screening their own people because the money you're paying them is derived in part from federal funds.
That's right. That's right.
So, you know, this is something that's very important. And it comes up a lot also with I mean, we've seen situations where, and an example would be, we saw, it was up on the East Coast, and it was a situation where a doctor had been excluded, but he hadn't lost his license. So he was perfectly, and he had his DEA license. It was perfectly legal for him to see patients and write prescriptions for controlled substances and for non-controlled substances. He saw a Medicare patient. He did not bill the Medicare program, but he wrote a prescription. That prescription then was taken to a pharmacy who filled it. The pharmacy ended up paying a lot of money in penalties because the government found out that they were filling and then billing the government for
Orders issued
by excluded parties.
Right.
Okay, so this is it's directly or indirectly, guys. So you need to be screening not just your employees, your vendors, your contractors, your volunteers, your referring doctors. Okay, because if it's a referring doctor who's excluded, that order's not going to be any good.
That's right. That's exactly right.
Got to be careful. Next slide. Okay, so what's the difference between these two? I mean, we've kind of talked a lot, and I know it gets really confusing, all right? Just an overview, what's the primary differences between the two programs?
So the primary difference would be that the OIG Exclusion List is actually a registry of individuals and entities that have been excluded from participation in the federal healthcare programs. The CMS Preclusion List is, again, a registry of healthcare providers and suppliers, but these individuals are precluded from receiving reimbursement for Part C Medicare Advantage and for Part D Medicare drug program.
Okay, next slide. And I think this is a continuation of what you were saying there.
That's right. The OIG Exclusion List has excluded parties that cannot participate directly or indirectly in the federal health care programs, including CHIP, FEHBP, TRICARE, and again, that extends to even volunteering your time. The preclusion list is essentially bad actors, as Robert has said, who cannot participate in Part C or Part D.
Next slide. The access, let's summarize that.
The access is definitely different. So for the preclusion list, as we have said previously, only CMS approved Part C and Part D payers have access to the preclusion list. The OIG exclusion list is available to the public. So you can go to the OIG website and search the listed excluded individuals and entities, the LEIE, and search there. But it is also important to remember that there are, I think, about 43 state Medicaid exclusion databases as well that exist on various state websites in various formats. Some are Excel spreadsheets, some are PDFs. And those all have to be screened as well, because if you're excluded in one state, you're excluded in all states. And theoretically, you should be on the OIG exclusion list if you are on a state list, but we see many times that communication does not always happen.
Unfortunately, only about half the states do what they're supposed to do, and that is report the folks on their Medicaid list for inclusion on the LEIE. Therefore, you have to, if you want to really, protect yourself against penalties, you have to check the LEIE and all the state lists, and that's physically impossible. Next slide. Now in addition to that, they also want you to check, the GSA, the varmint list, because that's a whole group of, that's another 150,000 people now that they cannot do business with the government.
That's right. That's right. So they don't want them to be participating with Medicare providers.
That's right.
Of course.
Yeah. So unfortunately, these are all, and as I said earlier, there's not a law that says you have to screen. But if you don't screen these hundreds of thousands of names every 30 days, and you accidentally employ someone who is excluded or contract with an entity that is excluded, you are subject to severe penalties up to and including exclusion yourself.
That's right. That's right. So it's very important that you're protecting yourself and you're taking the step of checking these lists.
Yep. Next slide. All right. The length of the sanction. Wow. Well, penalties, we talked about that. Next slide. Yeah, the length of the sanction. That's just all over the place. I mean, we've already kind of covered it. We talked about how preclusion based on revocation can be up to 10 years.
That's right. That's right.
Preclusion based on exclusion can be forever.
That's right.
Because even though it may only be a 5-year exclusion, if they don't go in and affirmatively get off of the list, they're still excluded. If they're still excluded, they're still precluded.
That's right. That's right. If you do not actually apply for reinstatement with the Office of the Inspector General for an exclusion, then you will remain on the exclusion list. That preclusion is going to remain as well. And exclusions, if you have a mandatory exclusion, there's a minimum mandatory period of 5 years that you'll be added to the exclusion list, but the OIG can impose additional time on top of that mandatory minimum. For permissive exclusions, that is up to OIG's discretion as to how long, but typically it's about 3 years for a permissive exclusion. But again, they have authority to add additional time to that as well. But again, as Robert said, you have to actively apply for reinstatement after the exclusion period ends to actually have the exclusion removed. And if there is a corresponding preclusion, that will end that preclusion as well. And if you have a state exclusion and a federal exclusion, you may have to take action in both.
Now, just one final little twist that I want to kind of throw on there before we go through the review questions.
Mm-hmm.
If you are an individual or an entity and you say, okay, the 5 years is up, that was 15 years ago, I want to be off the list. They don't just take you off the list. The first thing they're going to do is they're going to send you a questionnaire. And the questionnaire is going to say, well, we understand you went off the list and that your first 5 years were up. What have you been doing for the last 10 years?
That's right.
And, remember, if you lie to them, that could be the basis of a separate crime. Why did Martha Stewart go to jail? Not because she engaged in insider trading, because she lied to the government, to an agent specifically.
That's right.
So, the problem is this. If you start filling that out and you say, well, I was working for a home health agency that didn't do screening, but I was only there for 2 years and then I left, they're going to go after not just the individual, because the individual should have known they can't work there. They're going to go after the home health agency that employed them for the 2-year period, and they're going to go after penalties against them.
That's exactly right. That's exactly right.
So you may say, well, we have everybody clean today, so we're okay. We've missed that bullet. But unfortunately, if you have hired someone in the past and they have left and they were excluded, if they ever try to get off the list and they disclose they work for you, you may have significant liability facing you.
That's right. That's exactly right. So it's critical to be aware of this.
You got to screen ahead of time. Next slide. Okay, so let's talk about, these lists. The individuals on the list for the exclusion list is only, 100,000 or something like that. But then you got another 144,000 on, no, it's maybe 70,000 on the LEIE. Now the 144 to 150 on the GSA list. And then you got the 43 Medicaid lists. So you're already up to several 100,000. The preclusion list is going to include at least the LEIE.
That's right.
It's not going to, so that's going to be, 60 or 70,000 there. We talked about the different things that an individual can do to be put in on the preclusion list. It's either a revocation or bad conduct, bad behavior. Exclusion, it's everything from losing your license to being convicted of drug abuse or healthcare fraud, patient abuse. Are providers' patients notified when an effective provider is placed on the exclusion list? No, they're not. They're not. And that's the other thing. You want to screen because you don't want these people taking care of your patients. Okay, there's a reason why the government is so adamant about this. They think that they represent a risk to these patients. Okay, providers can check the exclusion list. They can't check the preclusion list. Does placement on the list cover Medicare and Medicaid claims?
Yes.
Yes, it does. And not just those, it covers all federal health benefit programs, FEHBP, railroad retirement, TRICARE. There's so many of them out there. And there's, if claims by an excluded party are paid or a precluded party are paid, what are the possible consequences? Well, that's no payment at the very least.
At the very least, that's right.
Okay, and then for both of them, if the term is up, does the name come off the list? No, not automatically. All right. So, I wish that my colleague Paul had actually, of course, as always, you did a wonderful job.
Thank you. Thank you for having me.
I'm lucky that you were here today because you actively are handling these cases and have been for years. Paul, on the other hand, is the CEO of Exclusion Screening, and that is one of the ways that you can screen. That's one of the companies that home health and hospices need to be screening, need to be doing, especially, there's no law on the federal side that says you have to screen, but if you hire someone, you get in trouble. That's not the case on Medicaid, guys, okay? In the Texas Medicaid Participation Agreement, as part of that agreement, you're swearing that you're screening.
That's right. That's right.
And you say you're screening for all states, not just Texas.
That's right. And just like Robert was saying previously, if you say that you are screening and you're not actively screening, that's a misstatement to the
It
government.
is, and the government, depending on the facts, could go after you criminally.
Mm-hmm.
There have been a couple of cases, thank goodness not Texas, in New York, where it was a practice, not a home health or hospice, but it was a practice, and there was a doctor who still had his license, but he had been excluded. He knew he couldn't, he can't get a job, so he was working at a practice. The other doc knew he was excluded. All of the excluded doctor services were being billed under the number of the non-excluded doctor. That's the kind of case that goes for, now that's something that you affirmatively know what you're supposed to be doing, and you take this subterfuge to avoid the rules.
Mm-hmm.
That really is a good example of how an exclusion action can lead to a criminal prosecution.
That's right.
For trying to get around it.
That's right. That's right.
So I do encourage you to call exclusionscreening.com if you have questions about your screening obligations. The other thing I want to tell you is it's not that expensive, okay? But it's something that you need to do to protect you and your patients.
That's right. And they have the ability to screen against all of the lists at one time, instead of you as a small home health or hospice provider trying to search 45 different lists.
It would be impossible. It would take at least 2 FTE every month to do that.
That's right. That's right.
And with that, we just want to say thank you so much for TAHCH having us, and we look forward to doing a webinar next month.
That's right.
I believe next month it's on reading the tea leaves.
Well, that'll be an exciting one. See
Yes.
what's coming.
Exactly.
Well, that concludes today's webinar. Thank you again for joining us, and thank you to our speakers, Robert Liles and Ashley Morgan. Everyone from today's webinar will receive copies of the presentation via email tomorrow. If you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to Robert or Ashley or directly to us, Liles Parker. Other than that, have a good Wednesday and take care.